Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey, just me again. I'm about to bring you part 2 of our multi-part series bringing you Andrews and the Law Society of British Columbia. If you want to hear me and Zach chat about the case, please head to the previous episode. I'm about to get into the reasons of Justice McIntyre. Hope you enjoy. The reasons of Justices McIntyre and Lemaire were delivered by Justice McIntyre. Justice McIntyre dissenting in part. This appeal raises only one question. Does the citizenship requirement for entry into the legal profession contained in Section 42 of the Barristers and Solicitors Act contravene Section 15(1) of the Charter? The respondent, Andrews, was a British subject permanently resident in Canada at the time these proceedings were commenced. He had taken law degrees at Oxford and had fulfilled all the requirements for admission to the practice of law in BC, except that of Canadian citizenship. He commenced proceedings for a declaration that Section 42 of the Act violates the Charter. He also sought an order in the nature of mandamus requiring the benchers of the Law Society of BC to consider his application for call to the bar and admission as a solicitor. His action was dismissed at trial before Justice Taylor in the Supreme Court of British Columbia. An appeal was allowed in the Court of Appeal, and this appeal is taken by the Law Society of BC by leave granted November 27, 1986, pursuant to an order of this court on January 28, 1987. Gore Elizabeth Kinserly, an American citizen who was at the time a permanent resident of Canadian Articling in the province of BC, was added as a co-respondent in this appeal. On January 28, 1987, the Chief Justice stated constitutional questions in the following terms. 1. Does the Canadian citizenship requirement to be a lawyer in the province of BC, as set out in Section 42 of the Barristers and Solicitors Act, infringe on or deny the rights guaranteed by Section 15(1) of the Charter? 2. If the Canadian citizenship requirement to be a lawyer in the province of BC, as set out in Section 42 of the Barristers and Solicitors Act, infringes or denies the rights guaranteed by Section 15(1) of the Charter, is it justified by Section 1 of the Charter? Following the judgment in his favor, the respondent Andrews was called to the bar and admitted as a solicitor in the province of British Columbia and is now a Canadian citizen. The co-respondent, Kinserly, who had expressed an intention to become a Canadian citizen, became eligible to do so on March 15, 1988. Disposition in the courts below. Justice Taylor, at trial, defined discrimination under Section 15(1) of the Charter as the drawing of an irrational distinction between people based on some irrelevant personal characteristic for the purpose, or having the effect, of imposing upon the victim of the discrimination some penalty, disadvantage, or indignity, or denying some advantage. He did not consider that the enumerated heads of discrimination in Section 15(1), race, national or ethnic origin, color, religion, sex, age, or mental or physical disability, were a complete listing of the prescribed bases of discrimination, and said at paragraph 16, quote, "Thus, in order to amount to discrimination under Section 15(1), the personal characteristic on which a distinction is based must either be one which is entirely irrelevant in the context which the distinction is made, or one which is given significance clearly beyond that which could reasonably be justified in such a context. The distinction must in this sense be irrational." End quote. He said that the test would be the same whether or not the discrimination was on the basis of a characteristic enumerated in Section 15 of the Charter. Citizenship, in his view, while not within the term national origin, is nonetheless a characteristic which could form a basis for discrimination under 15(1). He adopted a broad view of the concept of citizenship. He said, quote, "Citizenship is, I think, a privilege which is understood to carry with it commitments to promote the security and welfare of the country, and to protect the way of life in which Canadians have come to believe, which are not expected of a permanent resident, even a resident sworn to allegiance. A citizen is a part of the country, a resident non-citizen never really more than an attachment to it." End quote. In determining the relevance of citizenship to entry into the legal profession, he referred to the wide powers accorded to lawyers in the administration of justice and the judicial process, which give rise to a duty to protect the system from abuse and to respect the laws of the land. He said, quote, "It cannot, in my view, be said that there is anything irrational in the view which has been taken by the legislature that only Canadian citizens ought to exercise such powers in this province and be entrusted with such responsibilities," end quote. He did not consider that any burden imposed on non-citizens by the citizenship requirement was disproportionate to the relevance of citizenship in view of the nature of the duties and responsibilities of members of the legal profession. He concluded that neither Section 15.1 nor Section 7 of the Charter were infringed by the Canadian citizenship requirement in Section 42 of the Act. Appeal Justice McLaughlin wrote the judgment for a unanimous Court of Appeal. She expressed the view that the real meaning of the concept of equal protection and benefit before and under the law is that persons who are similarly situated be similarly treated, and conversely, that persons who are differently situated be differently treated. She referred to two competing approaches which have been adopted in dealing with discrimination under Section 15.1. One view is that any distinction is sufficient to establish discrimination, and when discrimination is found, the court should immediately turn to Section 1 of the Charter for determination of its constitutional validity. The other view is that discrimination under Section 15.1 must be invidious or pejorative in nature, in that it must result from an unreasonable classification or unjustifiable differentiation. The second view then incorporates principles of justification and reasonableness into Section 15.1 independently of Section 1. She adopted essentially the second view, rejecting the proposition that any differentiation would result in a resort to Section 1 of the Charter, arguing that it could not have been intended to give guarantee in Section 15.1 against every legislative classification. To do so, she asserted, would be to trivialize the fundamental rights guaranteed by the Charter and deprive the words "without discrimination" in Section 15.1 of any content, and in effect to replace Section 15.1 with Section 1. This approach, in her opinion, would mean that many important and socially accepted distinctions, such as restrictions on drunken driving and special provisions for the care, protection, and education of children, would be subject to automatic review under Section 1. To equate the provisions of Section 15.1 with the guarantee against all distinction would, in effect, elevate Section 15 to the position of subsuming the other rights and freedoms defined in the Charter. She said that there must be an initial determination of the reasonableness and fairness of the impugned legislation under Section 15.1. Therefore, she saw two questions emerge. What degree of evaluation of the legislation should be done under Section 15.1, and what role, if any, remained for Section 1 when legislation is attacked under Section 15.1? In dealing with the first question, she said that the court should determine whether the impugned distinction is reasonable or fair, having regard to its purposes and aims, and to its effect on the person concerned. She said, quote, "My response to the first question is that the question to be answered under Section 15 should be whether the impugned distinction is reasonable or fair, having regard to the purposes and aims and its effect on persons adversely affected." I include the word fair as well as reasonable to emphasize that the test is not one of pure rationality, but one connoting the treatment of persons in ways which are not unduly prejudicial to them. The test must be objective, and the discrimination must be proved on a balance of probabilities. The ultimate question is whether a fair-minded person, weighing the purposes of legislation against its effects on individuals adversely affected, and giving due weight to the right of the legislature to pass laws for the good of all, would conclude that the legislative means adopted are unreasonable or unfair, end quote. She went on to state that Section 1 would apply to permit discrimination in extraordinary circumstances, such as the internment of enemy aliens in wartime, which would create discrimination not to be tolerated in peacetime. She concluded that the citizenship requirement in the Act discriminated against the respondent. She rejected the Law Society's argument that the importance of the legal profession and the general scheme of the administration of the legal system justified the citizenship requirement. She reached the conclusion that the distinction deprived the respondent of the equal benefit of the law guaranteed under Section 15, and she concluded on this point by saying, quote, "In summary, none of the reasons offered for the requirement of citizenship for the practice of law offer a convincing justification for it. On the other hand, the requirement is clearly prejudicial to the appellant and those similarly placed. Having met all the other requirements for the admission to the bar, the appellant is nevertheless unable to gain admission to practice because he is not yet a Canadian citizen. I find that the appellant has discharged the onus upon him of showing that the requirement of citizenship for admission to the practice of law is unreasonable or unfair." End quote. The concept of equality. Section 15.1 of the Charter provides for every individual a guarantee of equality before and under the law, as well as the equal protection and equal benefit of the law without discrimination. This is not a general guarantee of equality. It does not provide for equality between individuals or groups within society in a general or abstract sense, nor does it impose on individuals or groups an obligation to accord equal treatment to others. It is concerned with the application of the law. No problem regarding the scope of the word law as employed in Section 15.1 can arise in this case because it is an act of the legislature which is under attack. Whether other governmental or quasi-governmental regulations, rules, or requirements may be termed laws under Section 15.1 should be left for cases in which the issue arises. The concept of equality has long been a feature of Western thought. As embodied in Section 15.1 of the Charter, it is an elusive concept, and more than any other rights and freedoms guaranteed in the Charter, it lacks precise definition. As has been stated by John H. Shar, quote, "Equality is a protean word. It is one of those political symbols, liberty and fraternity are others, into which men have poured the deepest urgings of their heart. Every strongly held theory or conception of equality is at once a psychology, an ethic, a theory of social relations, and a vision of the good society." End quote. It is a comparative concept, the condition of which may only be attained or discerned by comparison with the condition of others in the social and political setting in which the question arises. It must be recognized at once, however, that every difference in treatment between individuals under the law will not necessarily result in inequality, and, as well, that identical treatment may frequently produce serious inequality. This proposition has found frequent expression in the literature on the subject, but, as I have noted on a previous occasion, nowhere more aptly than in the well-known words of Justice Frankfurter in Dennis and the United States. Quote, "It was a wise man who said that there is no greater inequality than the equal treatment of unequals." End quote. The same thought has been expressed in this court in the context of Section 2B of the Charter, in the Queen and Big M Drug Mart Limited, where Chief Justice Dixon said at paragraph 347, quote, "The equality necessary to support religious freedom does not require identical treatment of all religions. In fact, the interests of true equality may well require differentiation in treatment." End quote. In simple terms, then, it may be said that a law which treats all identically and which provides equality of the treatment between A and B might as well cause inequality for C, depending on differences in personal characteristics and situations. To approach the ideal of full equality before and under the law, and in human affairs an approach is all that can be expected, the main consideration must be the impact of the law on the individual or the group concerned. Recognizing that there will always be an infinite variety of personal characteristics, capacities, entitlements, and merits among those subject to a law, there must be accorded, as nearly as may be possible, an equality of benefit and protection, and no more of the restrictions, penalties, or burdens imposed upon one than another. In other words, the admittedly unattainable ideal should be that a law expressed to bind all should not, because of irrelevant personal differences, have a more burdensome or less beneficial impact on one than another. Appeal Justice McLaughlin in the Court of Appeal expressed the view, at paragraph 605, that, quote, "The essential meaning of the constitutional requirement of equal protection and equal benefit is that persons who are similarly situated be similarly treated, and conversely, that persons who are differently situated be differently treated." End quote. In this, she was adopting and applying as a test a proposition which seems to have been widely accepted with some modifications in both trial and appeal court decisions throughout the country on Section 15.1 of the Charter. The reliance on this concept appears to have derived, at least in recent times, from J.T. Tussman and J. Tenbrook, The Equal Protection of Laws. The similarly situated test is a restatement of the Aristotelian principle of formal equality, that things that are alike should be treated alike, while things that are unalike should be treated unalike in proportion to their unalikeness. The test as stated, however, is seriously deficient in that it excludes any consideration of the nature of the law. If it were to be applied literally, it could be used to justify the Nuremberg laws of Adolf Hitler. Similar treatment was contemplated for all Jews. The similarly situated test would have justified the formalistic separate but equal doctrine of Plessy and Ferguson, a doctrine that incidentally was still the law in the United States at the time that Professor Tussman and J. Tenbrook wrote their much-cited article. The test, somewhat differently phrased, was applied in the British Columbia Court of Appeal in the Queen and Gonzales. The court upheld, under Section 1B of the Canadian Bill of Rights, a section of the Indian Act, which made it an offense for an Indian to have intoxicants in his possession off a reserve. In his locality, there were no reserves. Appeal Justice Tiso said that equality before the law could not mean the same laws for all persons, and defined the right in these words. Quote, in its context, Section 1B means in a general sense that there has existed and there shall continue to exist in Canada a right in every person to whom a particular law relates or extends, no matter what may be a person's race, national origin, color, religion, or sex, to stand on an equal footing with every other person to whom the particular law relates or extends, and a right to the protection of the law, end quote. This approach was rejected, in this court, by Justice Ritchie in The Queen and Drybones, a similar case involving a provision of the Indian Act making it an offense for an Indian to be intoxicated off a reserve. He said at paragraph 297, quote, I cannot agree with this interpretation pursuant to which it seems to me that the most glaring discriminatory legislation against a racial group would have to be construed as recognizing the right of each of its individual members to equality before the law, so long as all the other members are being discriminated against in the same way, end quote. Thus, mere equality of application to similarly situated groups or individuals does not afford a realistic test for a violation of equality rights. For, as it has been said, a bad law will not be saved merely because it operates equally upon those to whom it has application, nor will a law necessarily be bad because it makes distinctions. A similarly situated test focusing on the equal application of the law to those whom it has application could lead to results akin to those in Bliss and AG of Canada. In Bliss, a pregnant woman was denied unemployment benefits to which she would have been entitled had she not been pregnant. She claimed that the Unemployment Insurance Act violated the equality guarantees of the Canadian Bill of Rights because it discriminated against her on the basis of sex. Her claim was dismissed by this court on the grounds that there is no discrimination on the basis of sex, since the class into which she fell under the Act was that of pregnant persons, and within that class, all persons were treated equally. This case, of course, was decided before the advent of the Charter. I would also agree with the following criticism of the similarly situated test made by Appeal Justice Cairns in Mai and Alta. Quote, the test accepts an idea of equality which is almost mechanical, with no scope for considering the reason for the distinction. In consequence, subtleties are found to justify a finding of dissimilarity which reduces the test to a categorization game. Moreover, the test is not helpful. After all, most laws are enacted for the specific purpose of offering a benefit or imposing a burden on some persons and not on others. The test catches every conceivable difference in legal treatment, end quote. For the reasons outlined above, the test cannot be accepted as a fixed rule or formula for the resolution of equality concerns arising under the Charter. Consideration must be given to the content of the law, to its purpose, and its impact upon those to whom it applies, and also upon those whom it excludes from its application. The issues which will arise from case to case are such that it would be wrong to attempt to confine these considerations within such a fixed and limited formula. It is not every distinction or differentiation in treatment at law which will transgress the equality guarantees of Section 15 of the Charter. It is, of course, obvious that legislatures may, and to govern effectively must treat different individuals and groups in different ways. Indeed, such distinctions are one of the main preoccupations of legislatures. The classifying of individuals and groups, the making of different provisions respecting such groups, the application of different rules, regulations, requirements, and qualifications to different persons is necessary for the governance of modern society. As noted above, for the accommodation of differences, which is the essence of true equality, it will frequently be necessary to make distinctions. What kinds of distinctions will be acceptable under Section 15.1, and what kinds will violate its provisions? In seeking an answer to these questions, the provisions of the Charter must have their full effect. In the Queen and Big M Drug Mart Limited, this court emphasized this point at paragraph 344, where Chief Justice Dixon stated, quote, "This court has already, in some measure, set out the basic approach to be taken in interpreting the Charter." In Hunter and Southam, this court expressed the view that the proper approach to the definition of the rights and freedoms guaranteed by the Charter was a purposive one. The meaning of a right or freedom guaranteed by the Charter was to be ascertained by an analysis of the purpose of such a guarantee. It was to be understood, in other words, in the light of the interests it was meant to protect. In my view, this analysis is to be undertaken, and the purpose of the right or freedom in question is to be sought by reference to the character and the larger objects of the Charter itself, to the language chosen to articulate the specific right or freedom, to the historical origins of the concepts enshrined, and where applicable, to the meaning and purpose of the other specific rights and freedoms with which it is associated within the text of the Charter. The interpretation should be, as the judgment in Southam emphasizes, a generous rather than a legalistic one, aimed at fulfilling the purpose of the guarantee and securing for individuals the full benefit of the Charter's protection. At the same time, it is important not to overshoot the actual purpose of the right or freedom in question, but to recall that the Charter was not enacted in a vacuum, and must therefore, as this court's decision in Law Society of Upper Canada and Skapinker illustrates, be placed in its proper linguistic, philosophic, and historical contexts. These words are not inconsistent with the view I expressed in reference to Public Service Employees Relations Act. The principle of equality before the law has long been recognized as a feature of our constitutional tradition, and it found statutory recognition in the Canadian Bill of Rights. However, unlike the Canadian Bill of Rights, which spoke only of equality before the law, Section 15.1 of the Charter provides a much broader protection. Section 15 spells out 4 basic rights. 1. The right to equality before the law. 2. The right to equality under the law. 3. The right to equal protection of the law. And 4. The right to equal benefit of the law. The inclusion of these last 3 additional rights in Section 15 of the Charter was an attempt to remedy some of the shortcomings of the right to equality in the Canadian Bill of Rights. It also reflected the expanded concept of discrimination being developed under the various human rights codes since the enactment of the Canadian Bill of Rights. The shortcomings of the Canadian Bill of Rights, as far as the right to equality is concerned, are well known. In AG of Canada and Laval, for example, this court upheld Section 12(1)B of the Indian Act, which deprived women, but not men, of their membership in Indian bands if they married non-Indians. The provision was held not to violate equality before the law, although it might, the court said, violate equality under the law if such were protected. In Bliss, this court held that the denial of unemployment insurance benefits to women because they were pregnant did not violate the guarantee of equality before the law, because any inequality in the protection and benefit of the law was not created by legislation but by nature. The case was distinguished from the court's earlier decision in Dry Bones as not involving the imposition of a penalty on a racial group to which other citizens are not subjected, but involving rather a definition of the qualifications required for entitlement to a benefit. It is readily apparent that the language of Section 15 was deliberately chosen in order to remedy some of the perceived defects under the Canadian Bill of Rights. The antecedent statute is part of the linguistic, philosophic, and historical context of Section 15 of the Charter. It is clear that the purpose of Section 15 is to ensure equality in the formulation and application of the law. The promotion of equality entails the promotion of a society in which all are secure in the knowledge that they are recognized at law as human beings equally deserving of concern, respect, and consideration. It has a large remedial component. Chief Justice Howland and Appeal Justice Robbins, in reference an act to amend the Education Act, attempt to articulate the broad range of values embraced by Section 15. They state, quote, "In our view, Section 15.1, read as a whole, constitutes a compendious expression of a positive right to equality both in the substance and the administration of the law. It is an all-encompassing right governing all legislative action. Like the ideals of equal justice and equal access to the law, the right to equal protection and equal benefit of the law, now enshrined in the Charter, rests on the moral and ethical principle fundamental to a truly free and democratic society that all persons should be treated by the law on a footing of equality with equal concern and respect." End quote. It must be recognized, however, as well that the promotion of equality under Section 15 has a much more specific goal than the mere elimination of distinctions. If the Charter was intended to eliminate all distinctions, then there would be no place for sections such as 27, Multicultural Heritage, 2A, Freedom of Conscience and Religion, 25, Aboriginal Rights and Freedoms, and other such provisions designed to safeguard certain distinctions. Moreover, the fact that identical treatment may frequently produce serious inequality is recognized in Section 15.2, which states that the equality rights in Section 15.1 do not preclude any law, program, or activity that has as its object the amelioration of conditions of disadvantaged individuals or groups. Discrimination. The right to equality before and under the law and the rights to the equal protection and benefit of the law contained in Section 15 are granted with the direction contained in Section 15 itself that they be without discrimination. Discrimination is unacceptable in a democratic society because it epitomizes the worst effects of the denial of equality, and discrimination reinforced by law is particularly repugnant. The worst oppression will result from discriminatory measures having the force of law. It is against this evil that Section 15 provides a guarantee. Discrimination, as referenced to in Section 15 of the Charter, must be understood in the context of pre-Charter history. Prior to the enactment of Section 15, the legislatures of various provinces and the federal parliament had passed during the previous 50 years what may be generally referred to as human rights acts. With the steady increase in population from the earliest days of European emigration into Canada, and with the consequential growth of industry, agriculture, and commerce, and the vast increase in national wealth which followed, many social problems developed. The contact of the European immigrant with the indigenous population, the steady increase in immigration bringing those of neither French nor British background, and in more recent years the greatly expanded role of women in all forms of industrial, commercial, and professional activity led to much inequality and many forms of discrimination. In great part, these developments, in the absence of any significant legislative protection for victims of discrimination, called into being the Human Rights Acts. In 1944, the Racial Discrimination Act was passed, to be followed in 1947 by the Saskatchewan Bill of Rights Act, and in 1960 by the Canadian Bill of Rights. Since then, every jurisdiction in Canada has enacted broad-ranging human rights acts, which have attacked most of the more common forms of discrimination found in society. This development has been recorded and discussed by Walter Tarnopolsky, now Appeal Justice Tarnopolsky, in Discrimination and the Law. What does discrimination mean? The question has arisen most commonly in a consideration of the Human Rights Acts, and the general concept of discrimination under those enactments has been fairly well settled. There is little difficulty drawing upon cases in this court in isolating an acceptable definition. In Ontario Human Rights Commission and O'Malley and Simpson Sears Limited, discrimination, in that case adverse effect discrimination, was described in these terms. It arises where an employer adopts a rule or standard which has a discriminatory effect upon a prohibited ground on one employee or a group of employees in that it imposes, because of some special characteristic of the employee or the group, obligations, penalties, or restrictive conditions not imposed on other members of the workforce. It was held in that case as well that no intent was required as an element of discrimination, for it is in essence the impact of the discriminatory act or provision upon the person affected which is decisive in considering any complaint. At page 547, this proposition was expressed in these terms. Quote, "The Code aims at the removal of discrimination. This is to state the obvious. Its main approach, however, is not to punish the discriminator, but rather to provide relief for the victims of discrimination. It is the result or the effect of the action complained of which is significant. If it does in fact cause discrimination, if its effect is to impose on one person or group of persons obligations, penalties, or restrictive conditions not imposed on other members of the community, it is discriminatory." End quote. In Canadian National Railway Company and Canada, Canadian Human Rights Commission, better known as the Action Travail de Femme case, where it was alleged that the Canadian National Railway was guilty of discriminatory hiring and promotion practices contrary to Section 10 of the Canadian Human Rights Act in denying employment to women in certain unskilled positions, Chief Justice Dixon, in giving the judgment of the court, said, quote, "A thorough study of systemic discrimination in Canada is to be found in the Abella Report on Equality in Employment. The terms of reference of the Royal Commission instructed it to inquire into the most efficient, effective, and equitable means of promoting employment opportunities, eliminating systemic discrimination, and assisting individuals to compete for employment opportunities on an equal basis. Although Judge Abella chose not to offer a precise definition of systemic discrimination, the essentials may be gleaned from the following comments found in the report. Discrimination means practices or attitudes that have, whether by design or impact, the effect of limiting an individual or a group's right to the opportunities generally available because of attributed rather than actual characteristics. It is not a question of whether this discrimination is motivated by an intentional desire to obstruct someone's potential, or whether it is the accidental byproduct of innocently motivated practices or systems. If the barrier is affecting certain groups in a disproportionately negative way, it is a signal that the practices that led to this adverse impact may be discriminatory. There are many other statements which have aimed at a short definition of the term discrimination. In general, they are in accord with the statements referred to above. I would say then that discrimination may be described as a distinction, whether intentional or not, but based on grounds relating to personal characteristics of the individual or group, which has the effect of imposing burdens, obligations, or disadvantages on such individual or group not imposed upon others, or which withholds or limits access to opportunities, benefits, and advantages available to other members of society. Distinctions based on personal characteristics attributed to an individual solely on the basis of association with a group will rarely escape the charge of discrimination, while those based on an individual's merits and capacities will rarely be so classed. The court in the case at bar must address the issue of discrimination as the term is used in Section 15.1 of the Charter. In general, it may be said that the principles which have been applied under the Human Rights Act are equally applicable in considering questions of discrimination under 15.1. Certain differences arising from the differences between the Charter and the Human Rights Acts must, however, be considered. To begin with, discrimination in Section 15.1 is limited to discrimination caused by the application or operation of law, whereas the Human Rights Acts also apply to private activities. Furthermore, and this is a distinction of more importance, all of the Human Rights Acts passed in Canada specifically designate a certain limited number of grounds upon which discrimination is forbidden. Section 15.1 of the Charter is not so limited. The enumerated grounds in Section 15.1 are not exclusive, and the limits, if any, on grounds for discrimination which may be established in future cases await definition. The enumerated grounds do, however, reflect the most common and probably the most socially destructive and historically practiced bases of discrimination, and must, in the words of Section 15.1, receive particular attention. Both the enumerated grounds themselves and other possible grounds of discrimination recognized under Section 15.1 must be interpreted in a broad and generous manner, reflecting the fact that they are constitutional provisions not easily repealed or amended, but intended to provide a continuing framework for the legitimate exercise of governmental power, and at the same time, for the unremitting protection of equality rights. It should be noted as well that when the Human Rights Acts create exemptions or defenses, such as a bona fide occupational requirement, an exemption for religious and political organizations, or definitional limits on age discrimination, these generally have the effect of completely removing the conduct complained of from the reach of the Act. Age is often restrictively defined in the Human Rights Acts. In British Columbia, it is defined in Section 1 of the Code to mean an age between 45 and 65. In Section 38 of the Individuals' Rights Protections Act, it is defined as 18 and over. For an example of the application of a bona fide occupational requirement, see Binder and Canadian National Railway Company. Where discrimination is forbidden in the Human Rights Acts, it is done in absolute terms, and where a defense or exception is allowed, it too speaks in absolute terms, and the discrimination is excused. There is, in this sense, no middle ground. In the Charter, however, while Section 15.1, subject always to Section 15.2, expresses its prohibition of discrimination in absolute terms, Section 1 makes allowance for a reasonable limit upon the operation of Section 15.1. A different approach under Section 15.1 is therefore required. While discrimination under Section 15.1 will be of the same nature and in descriptive terms will fit the concept of discrimination developed under the Human Rights Acts, a further step will be required in order to decide whether discriminatory laws can be justified under Section 1. The onus will be on the state to establish this. This is a distinct step called for under the Charter, which is not found in most Human Rights Acts, because in those acts, justification for or defense to discrimination is generally found in specific exceptions to the substantive rights. Relationship between Section 15.1 and Section 1 of the Charter. In determining the extent of the guarantee of equality in Section 15.1 of the Charter, special consideration must be given to the relationship between Section 15.1 and Section 1. It is indeed the presence of Section 1 in the Charter and the interaction between these sections which has led to the differing approaches to a definition of the Section 15 right, in which has made necessary a judicial approach differing from that employed under the Canadian Bill of Rights. Under the Canadian Bill of Rights, a test was developed to distinguish between justified and unjustified legislative distinctions within the concept of equality before the law itself in the absence of anything equivalent to the Section 1 limit. It may be noted as well that the 14th Amendment to the American Constitution, which provides that no state shall deny to any person within its jurisdiction the equal protection of the laws, contains no limiting provision similar to Section 1 of the Charter. As a result, judicial consideration has led to the development of varying standards of scrutiny of alleged violations of the equal protection provision, which restrict or limit the equality guarantee within the concept of equal protection itself. Again, Article 14 of the European Convention on Human Rights, which secures the rights guaranteed therein without discrimination, lacks a Section 1 or its equivalent and has also developed a limit within the concept itself. In the Belgian linguistics case number 2, the court enunciated the following tests. Quote, "The principle of equality of treatment is violated if the distinction has no objective and reasonable justification. The existence of such a justification must be assessed in relation to the aim and effects of the measure under consideration, regard being had to principles which normally prevail in democratic societies. A difference in treatment in the exercise of a right laid down in the Convention must not only pursue a legitimate aim. Article 14 is likewise violated when it is clearly established that there is no reasonable relationship of proportionality between the means employed and the aims sought to be realized." End quote. The distinguishing feature of the Charter, unlike the other enactments, is the consideration of such limiting factors is made under Section 1. This court has described the analytical approach to the Charter in the Queen and Oaks, the Queen and Edwards Books and Art Limited, and other cases, the essential feature of which is that the right guaranteeing sections be kept analytically separate from Section 1. In other words, when confronted with a problem under the Charter, the first question which must be answered will be whether or not an infringement of a guaranteed right has occurred. Any justification of an infringement which is found to have occurred must be made, if at all, under the broad provisions of Section 1. It must be admitted at once that the relationship between these two sections may well be difficult to determine on a wholly satisfactory basis. It is, however, important to keep them analytically distinct, if for no other reason than the different attribution of the burden of proof. It is for the citizen to establish that his or her charter right has been infringed on, and for the state to justify the infringement. Approaches to Section 15.1. 3 main approaches have been adopted in determining the role of Section 15.1, the meaning of discrimination set out in the section, and the relationship of Section 15.1 and Section 1. The first one, which was advanced by Professor Peter Hogg in Constitutional Law of Canada, would treat every distinction drawn by the law as discrimination under 15.1. There would then follow a consideration of the distinction under the provision of Section 1 of the Charter. He said, quote, "I conclude that Section 15 should be interpreted as providing for the universal application of every law. When a law draws a distinction between individuals on any ground, that distinction is sufficient to constitute a breach of Section 15 and to move the constitutional issue to Section 1. The test of validity is that stipulated by Section 1, namely, whether the law comes within the phrase such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society." End quote. He reached this conclusion on the basis that, where the charter right is expressed in unqualified terms, Section 1 supplies the standard of justification for any abridgment of the right. He argued that the word discrimination in Section 15.1 could be read as introducing a qualification in the section itself, but he preferred to read the word in a neutral sense because this reading would immediately send the matter to Section 1, which was included in the Charter for this purpose. The second approach put forward by Appeal Justice McLaughlin in the Court of Appeal involved a consideration of the reasonableness and fairness of the impugned legislation under Section 15.1. She stated, as has been noted above, at paragraph 610, quote, "The ultimate question is whether a fair-minded person, weighing the purposes of legislation against its effects on the individuals adversely affected, and giving due weight to the right of the legislature to pass laws for the good of all, would conclude that the legislative means adopted are unreasonable or unfair." End quote. She assigned a very minor role to Section 1, which would, it appears, be limited to allowing in times of emergency, war, or other crises, the passage of discriminatory legislation, which would normally be impermissible. A third approach, sometimes described as an enumerated or analogous grounds approach, adopts the concept that discrimination is generally expressed by the enumerated grounds. Section 15.1 is designed to prevent discrimination based on these and analogous grounds. The approach is similar to that found in human rights and civil rights statutes, which have been enacted throughout Canada in recent times. The following excerpts from the judgment of Appeal Justice Hugesson in Smith, Kline and French Laboratories in Canada illustrate this approach. Quote, "The rights which it guarantees are not based on any concept of strict numerical equality amongst all human beings. If they were, virtually all legislation, whose function it is, after all, to define, distinguish, and make categories, would be in a prima facie breach of Section 15 and would require justification under Section 1. This would be to turn the exception into the rule. Since courts would be obliged to look for and find Section 1 justification for most legislation, the alternative being anarchy, there is a real risk of paradox. The broader the reach given to Section 15, the more likely it is that it will be deprived of any real content. The answer, in my view, is that the text of this section itself contains its own limitations. It only proscribes discrimination amongst the members of categories which are themselves similar. Thus, the issue for each case will be to know which categories are permissible in determining similarity of situation and which are not. It is only in those cases where the categories themselves are not permissible, where equals are not treated equally, that there will be a breach of equality rights." End quote. As far as the text of Section 15 itself is concerned, one may look to whether or not there is discrimination in the pejorative sense of the word, and as to whether the categories are based upon the grounds enumerated or grounds analogous to them. The inquiry, in effect, concentrates upon the personal characteristics of those who claim to have been unequally treated. Questions of stereotyping, of historical disadvantagement, in a word, of prejudice, are the focus, and there may even be a recognition that for some people, equality has a different meaning than for others. The analysis of discrimination in this approach must take place within the context of the enumerated grounds and those analogous to them. The words "without discrimination" require more than a mere finding of distinction between the treatment of groups or individuals. Those words are a form of qualifier built into Section 15 itself and limit those distinctions which are forbidden by this section and to those which involve prejudice or disadvantage. I would accept the criticisms of the first approach made by Appeal Justice McLaughlin in the Court of Appeal. She noted that labeling of every legislative distinction as an infringement of Section 15(1) trivializes the fundamental rights guaranteed by the Charter, and, secondly, that to interpret without discrimination as without distinction deprives the notion of discrimination of content. She continued, quote, "Third, it cannot have been the intention of Parliament that the government be put to the requirement of establishing under Section 1 that all laws which draw distinction between people are demonstrably justified in a free and democratic society. If weighing of the justifiability of unequal treatment is neither required or permitted under Section 15, the result will be that such universally accepted and manifestly desirable legal distinctions as those prohibiting children or drunk persons from driving motor vehicles will be viewed as violations of fundamental rights and be required to run the gauntlet of Section 1. End quote. Finally, it may further be contended that to define discrimination under Section 15 as synonymous with unequal treatment on the basis of personal classification will be to elevate Section 15 to the position of subsuming the other rights and freedoms defined by the Charter. In rejecting the Hogg approach, I would say that it draws a straight line from the finding of a distinction to a determination of its validity under Section 1, but my objection would be that it virtually denies any role for Section 15(1). I would reject as well the approach adopted by Appeal Justice McLaughlin. She seeks to define discrimination under Section 15(1) as an unjustifiable or unreasonable distinction. In so doing, she avoids the mere distinction test, but also makes a radical departure from the analytical approach to the Charter, which has been approved by this Court. In the result, the determination would be made under Section 15(1), and virtually no role would be left for Section 1. The third, or enumerated and analogous grounds approach, most closely accords with the purposes of Section 15 and the definition of discrimination outlined above, and leaves questions of justification to Section 1. However, in assessing whether a complainant's rights have been infringed under Section 15(1), it is not enough to focus only on the alleged ground of discrimination and decide whether or not it is an enumerated or analogous ground. The effect of the impugned distinction or classification on the complainant must be considered. Once it is accepted that not all distinctions and differentiations created by law are discriminatory, then a role must be assigned to Section 15(1), which goes beyond the mere recognition of a legal distinction. A complaint under Section 15(1) must show not only that he or she is not receiving equal treatment before and under the law, or that the law has a differential impact on him or her in the protection or benefit accorded by law, but, in addition, must show that the legislative impact of the law is discriminatory. Where discrimination is found, a breach of Section 15(1) has occurred, and where Section 15(2) is not applicable, any justification, any consideration of the reasonableness of the enactment, indeed, any consideration of factors which could justify the discrimination and support the constitutionality of the impugned enactment, would take place under Section 1. This approach would conform with the directions of this Court in earlier decisions concerning the application of Section 1, and at the same time would allow for screening out of the obviously trivial and vexatious claim. In this, it would provide a workable approach to the problem. It would seem to me apparent that a legislative distinction has been made by Section 42 of the Barristers and Solicitors Act between citizens and non-citizens with respect to the practice of law. The distinction would deny admission to the practice of law to non-citizens who in all other respects are qualified. Have the respondents, because of Section 42 of the Act, been denied equality before and under the law or the equal protection of the law? In practical terms, it should be noted that the citizenship requirement affects only those non-citizens who are permanent residents. The permanent resident must wait for a minimum of 3 years from the date of establishing permanent resident status before citizenship may be acquired. The distinction therefore imposes a burden in the form of some delay on permanent residents who have acquired all or some of their legal training abroad and is therefore discriminatory. The rights guaranteed in Section 15.1 apply to all persons, whether citizens or not. A rule which bars an entire class of persons from certain forms of employment solely on the grounds of a lack of citizenship status and without consideration of the educational and professional qualifications or the other attributes or merits of individuals in the group would, in my view, infringe Section 15 equality rights. Non-citizens, lawfully permanent residents of Canada, are, in the words of the U.S. Supreme Court in United States and Caroline Products, and subsequently affirmed in Graham and Richardson, a good example of a discrete and insular minority who come within the protection of Section 15. Section 1. Having accepted the proposition that Section 42 has infringed on the right to equality guaranteed in Section 15, it remains to consider whether, under the provisions of Section 1 of the Charter, the citizenship requirement which is clearly prescribed by law is a reasonable limit which can be demonstrably justified in a free and democratic society. The onus of justifying the infringement of a guaranteed charter right must, of course, rest upon the parties seeking to uphold the limitation, in this case, the AG of British Columbia and the Law Society of British Columbia. As is evident from the decisions of this court, there are two steps involved in the Section 1 inquiry. First, the importance of the objective underlying the impugned law must be assessed. In Oakes, it was held that to override a charter-guaranteed right, the objective must relate to concerns which are pressing and substantial in a free and democratic society. However, given the broad ambit of legislation which must be enacted to cover various aspects of the civil law, dealing largely with administrative and regulatory matters, and the necessity for the legislature to make many distinctions between individuals and groups for such purposes, the standard of pressing and substantial may be too stringent for application in all cases. To hold otherwise would frequently deny the community at large the benefits associated with sound social and economic legislation. In my opinion, in approaching a case such as the one before us, the first question the court should ask must relate to the nature and the purpose of the enactment, with a view to deciding whether the limitation represents a legitimate exercise of the legislative power for the attainment of a desirable social objective which would warrant overriding constitutionally protected rights. This second step in a Section 1 inquiry involves the proportionality test, whereby the court must attempt to balance a number of factors. The court must examine the nature of the right, the extension of its infringement, and the degree to which the limitation furthers the attainment of the desirable goal embodied in the legislation. Also involved in the inquiry will be the importance of the right to the individual or group concerned, and the broader social impact of both the impugned law and its alternatives. As the Chief Justice has stated in the Queen and Edwards Books and Art Limited, quote, both in articulating the standard of proof and in describing the criteria composing the proportionality requirement, the court has been careful to avoid rigid and inflexible standards, end quote. I agree with this statement. There is no single test under Section 1. Rather, the court must carefully engage in the balancing of many factors in determining whether an infringement is reasonably and demonstrably justified. The Section 15.1 guarantee is the broadest of all guarantees. It applies to and supports all other rights guaranteed by the Charter. However, it must be recognized that Parliament and the legislature have a right and a duty to make laws for the whole community. In this process, they must make innumerable legislative distinctions and categorizations in the pursuit of the role of government. When making distinctions between groups and individuals to achieve desirable social goals, it will rarely be possible to say of any legislative distinction that it is clearly the right legislative choice or that it is clearly a wrong one. As stated by the Chief Justice in the Queen and Edwards Books and Art Limited, quote, a reasonable limit is one which, having regard to the principles enunciated in Oakes, it was reasonable for the legislature to impose. The courts are not called upon to substitute judicial opinions for legislative ones as to the place at which to draw a precise line, end quote. In dealing with the many problems that arise, legislatures must not be held to the standard of perfection, for in such matters perfection is unattainable. I would repeat the words of my colleague Justice Laforêt in the Queen and Edwards Books and Art Limited. Quote, "By the foregoing, I do not mean to suggest that this court should, as a general rule, defer to legislative judgments when those judgments trench upon rights considered fundamental in a free and democratic society. Quite the contrary, I would have thought the Charter established the opposite regime. On the other hand, having accepted the importance of the legislative objective, one must, in the present context, recognize that if the legislative goal is to be achieved, it will inevitably be achieved to the detriment of some. Moreover, attempts to protect the rights of one group will also inevitably impose burdens on the rights of other groups. There is no perfect scenario in which the rights of all can be equally protected." End quote. In seeking to achieve a goal that is demonstrably justified in a free and democratic society, therefore, a legislature must be given reasonable room to maneuver to meet these conflicting pressures. Disposition. I now turn to the case at bar. The Appellant Law Society in oral argument stressed 3 points. It argued that the Court of Appeal was correct in its analysis of the relationship between Section 15.1 and Section 1 of the Charter, but that it erred in applying criteria properly to be considered in Section 1 in deciding whether there was a breach of Section 15.1. This argument has been discussed and disposed of above. It was further argued that the Court of Appeal erred in its consideration of the citizenship requirement in Section 42 of the Barristers and Solicitors Act, in failing to give proper weight to the importance of the role of the legal profession in the legal and governmental processes of the country, and in failing to consider that Canadian citizenship could reasonably be regarded by the legislature as a requirement for the practice of law. The Law Society argued as well that because of the important duties and powers accorded to lawyers, they do indeed play a vital role in the governmental processes of the country, and that, while generally citizenship requirements are discriminatory in nature, the involvement of lawyers in the administration of justice justified the citizenship requirement. The Attorney General of British Columbia supported these arguments and, as well, argued that for the court to intervene and strike down the citizenship requirement would exceed the proper limits of judicial review. The respondents in general supported the judgment of the Court of Appeal. They argued that citizenship bears no clear relationship to an individual's personal and professional characteristics, and questioned the classification of lawyers as significant actors in the state or governmental process. While conceding that a citizenship requirement for many intimately concerned with the governing process for the country would be proper and sustainable, it was argued that the relationship of the legal profession to government and the administration of justice was not such that the citizenship requirement could be considered a reasonable requirement, and that any general helpfulness of the citizenship requirement in attaining the objectives of the Barristers and Solicitors Act could not suffice to justify the form of discrimination against an individual. In essence, the difference between the parties centered on the question of the importance of the legal profession in the government of the country. There is no difficulty in determining that in general terms, the Barristers and Solicitors Act of British Columbia is a statute enacted for a valid and desirable social purpose, the creation and regulation of the legal profession and the practice of law. The narrower question, however, is whether the requirement that only citizens be admitted to the practice of law in British Columbia serves a desirable social purpose of sufficient importance to warrant overriding the equality guarantee. It is incontestable that the legal profession plays a very significant, in fact, a fundamentally important, role in the administration of justice, both in the criminal and civil law. I would not attempt to answer the question arising from the judgments below as to whether the function of the profession may be termed judicial or quasi-judicial, but I would observe that in the absence of an independent legal profession skilled and qualified to play its part in the administration of justice and the judicial process, the whole legal system would be in a parlous state. In the performance of what may be called his private function, that is, in advising on legal matters and in representing clients before the courts and other tribunals, the lawyer is accorded great powers not permitted to other professionals. As pointed out by Justice Taylor at first instance, by the use of the subpoena which he alone can procure on behalf of another, he can compel attendance upon examinations before trial and at trial upon pain of legal sanction for refusal. He may as well require the production of documents and records for examination and use in the proceedings. He may in some cases require the summoning of jurors, the sittings of courts, and in addition, he may make the fullest inquiry into the matters before the court with a full privilege against actions for slander arising out of his conduct in the court. The solicitor is also bound by the solicitor and client privilege against the disclosure of communications with his client concerning legal matters. This is said to be the only absolute privilege known to the law. Not only may the solicitor decline to disclose solicitor and client communications, the courts will not permit him to do so. This is a privilege against all comers, including the Crown, save where the disclosure of a crime would be involved. The responsibilities involved in its maintenance and in its breach where crimes are concerned are such that citizenship, with its commitment to the welfare of the whole community, is not an unreasonable requirement for the practice of law. While it may be arguable whether the lawyer exercises a judicial, quasi-judicial, or governmental role, it is clear that at his own discretion he can invoke the full force and authority of the state in procuring and enforcing judgments or other remedial measures which may be obtained. It is equally true that in defending an action he has the burden of protecting his client from the imposition of such state authority and power. By any standard, these powers and duties are vital to the maintenance of order in our society and the due administration of the law in the interest of the whole community. The lawyer has as well what may be termed a public function. Governments at all levels, federal, provincial, and municipal, rely extensively upon lawyers, both in technical and policy matters. In the drafting of legislation, regulations, treaties, agreements, and other governmental documents, and paper lawyers play a major role. In various aspects of this work, they are called upon to advise upon legal and constitutional questions, which frequently go to the very heart of the governmental role. To discharge these duties, familiarity is required with Canadian history, constitutional law, regional differences, and concerns with the country and, in fact, with the whole Canadian governmental and political process. It is entirely reasonable, then, that legislators consider and adopt measures designed to maintain within the legal profession a body of qualified professionals with a commitment to the country and to the fulfillment of the important tasks which fall to it. Appeal Justice McLaughlin was of the view that the citizenship requirement would not ensure familiarity with Canadian institutions and customs, nor would it ensure a commitment to Canada going beyond one involved in the concept of allegiance, as recognized by the taking of an oath of allegiance. I would agree with her that the desired results would not be ensured by the citizenship requirement, but I would observe at the same time that no law will ever ensure anything. To abolish the requirement of citizenship on the basis that it would fail to ensure the attainment of its objectives would, in my view, be akin to abolishing the law against theft, for it has certainly not ensured the elimination of that crime. Citizenship, however, which requires the taking on of obligations and commitments to the community, difficult sometimes to describe but felt and understood by most citizens, as well as the rejection of past loyalties, may reasonably be said to conduce the desired result. I would observe as well that the comment of Appeal Justice McLaughlin that the citizenship requirement was first adopted in British Columbia in 1971 requires some explanation. I do not think that the historical argument should be pushed too far. Things need not always remain as once they were, although, as noted in the Queen and Big M Drug Mart Limited and reference Re Public Service Employee Relations Act, charter construction should be consistent with the history, traditions, and social philosophies of our society. The concept of citizenship has been a requirement for entry into the legal profession in British Columbia from its earliest days. When the Law Society was formed in 1874, the profession was open to British subjects. At the time, the idea of a separate Canadian citizenship, as distinct from the general classification of British subject which included Canadians, was scarcely known. Though as early as 1910 the term Canadian citizen was defined for the purposes of the Immigration Act as a British subject who has Canadian domicile. The concept of citizenship in those early days was embodied in the expression British subject, and thus it was recognized as a requirement for entry into the legal profession in British Columbia. As Canada moved away from its colonial past, a separate identity for Canadians emerged, and in 1946, with the passage of the Canadian Citizenship Act, the term Canadian citizen was formally recognized, giving effect to what had long been felt and accepted by most Canadians. In adopting the term as a qualification for entry into the legal profession in British Columbia, the legislature was merely continuing its earlier requirement that the concept of citizenship, as then recognized in the term British subject, be necessary for entry into the profession. Public policy, of which the citizenship requirement in the Barristers and Solicitors Act is an element, is for the legislature to establish. The role of the Charter, as applied by the courts, is to ensure that in applying public policy, the legislature does not adopt measures which are not sustainable under the Charter. It is not, however, for the courts to legislate or to substitute their own views on public policy for those of the legislature. I would repeat for ease of reference the words of the Chief Justice in the Queen and Edwards Books and Art Limited. Quote, "A reasonable limit is one which, having regard to the principles enunciated in Oakes, it was reasonable for the legislature to impose. The courts are not called upon to substitute judicial opinions for legislative ones as to the place at which to draw a precise line." End quote. The function of the court is to measure the legislative enactment against the requirements of the Charter, and where the enactment infringes the Charter, in this case the provisions of 15.1, and is not sustainable under Section 1, the remedial power of the court is set out in Section 15.2 of the Constitution Act. Quote, "Any law that is inconsistent with the provisions of the Constitution is to the extent of the inconsistency of no force and effect." End quote. The essence of Section 1 is found in the expression reasonable, and it is for the court to decide if Section 42 of the Barristers and Solicitors Act of British Columbia is a reasonable limit. In reaching the conclusion that it is, I would say that the legislative choice in this regard is not one between an answer that is clearly right and one that is clearly wrong. Either position may well be sustainable, and, as noted by the Chief Justice, the court is not called upon to substitute its own opinion as to where to draw the line. The legislature, in fixing public policy, has chosen the citizenship requirement, and unless the court can find that choice unreasonable, it has no power under the Charter to strike it down, or, as has been said, no power to invade the legislative field and substitute its views for that of the legislature. In my view, the citizenship requirement is reasonable and sustainable under Section 1. It is chosen for the achievement of a desirable social goal, one aspect of the due regulation and qualification of the legal profession. This is an objective of importance, and the measure is not disproportionate to the object to be attained. The maximum delay imposed upon the non-citizen from the date of acquisition of permanent resident status is 3 years. It will frequently be less. No impediment is put in the way of obtaining citizenship. In fact, the policy of the Canadian government is to encourage a newcomer to become a citizen. It is reasonable, in my view, to expect that the newcomer who seeks to gain the privileges and status within the land and the right to exercise the great powers that admission to the practice of law will give should accept citizenship and its obligations as well as its advantages and benefits. I would therefore allow the appeal and restore the judgment at trial. I would answer the constitutional questions as follows. 1. Does the Canadian citizenship requirement to be a lawyer in the province of BC, as set out in Section 42 of the Barristers and Solicitors Act, infringe or deny the rights guaranteed by Section 15.1 of the Charter? Yes. If the Canadian citizenship requirement to be a lawyer in the province of BC, as set out in Section 42 of the Barristers and Solicitors Act, infringes or denies the rights guaranteed by 15.1 of the Charter, is it justified by Section 1 of the Charter? Yes.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.